Judgment in the matter of Jardine Strategic Limited against Oasis Investments Master Fund and 80 others, number 2.
This appeal from the Court of Appeal of Bermuda raises the question, common to Bermudian and English law, whether a limited company can claim legal advice privilege against its shareholders when litigation arises between them, such that it can withhold from them documents containing or recording that legal advice. The need to get to the truth in civil litigation is buttressed by the mutual obligation of opposing parties to disclose and then produce for inspection by the other side relevant documents, including documents which harm their case. But it has for centuries been a recognized exception that a party is not obliged to give inspection of documents containing legal advice. Such documents are described as privileged from production. This privilege, often called legal advice privilege, recognizes and gives effect to the fundamental right of persons, including artificial persons like companies, to obtain confidential legal advice about their affairs without the fear that it may later have to be disclosed to someone who may wish to use it to harm them. A requirement to have to disclose that advice to a hostile opponent if the subject matter of the advice later becomes the subject of litigation would inhibit persons from taking that advice in the first place. Thus, legal advice privilege has come to be regarded as a fundamental condition upon which the administration of justice rests. There are very few exceptions to legal advice privilege. If it applies, the court has no discretion to override it. But, beginning in cases in the 1880s, it came to be regarded as a rule of English law that a company cannot claim legal advice privilege against its own shareholders as a ground for refusing production of documents when in litigation with them. I will call it the shareholder rule. Its original justification was that, since shareholders were thought collectively to be the beneficial owners of the assets of the company and contributed the capital out of which the advice was paid for, it was wrong to deny them access to the advice for which they had paid. It was based upon an analogy with a similar rule, which I will call the trustee rule, which applied between trustees and their beneficiaries. The present case arises out of the amalgamation between two Bermuda-registered companies in the Jardine Matheson Group. One of them was Jardine Strategic Holdings Limited, which I'll call Jardine Strategic. The amalgamated company is called Jardine Strategic Limited. I will call it the company. Under the statutory scheme for mergers and amalgamations in force in Bermuda, the amalgamation required all the shares in Jardine Strategic to be cancelled, and those who opposed the amalgamation to be offered fair value for their shares by the company. Shareholders who were dissatisfied with the fair value offered by the company had a right to have that fair value determined by the court. The company offering the opposing shareholders The company offered the opposing shareholders $33 per share, but they were dissatisfied with that offer and started proceedings against the company in the commercial court in Bermuda for a fair value determination. The shareholders sought disclosure of the legal advice given to the Jardine Matheson Group about the amount to be offered as fair value. The company claimed legal advice privilege, but the shareholders relied upon the exception from privilege constituted by the shareholder rule. Both the Commercial Court and the Court of Appeal in Bermuda applied the shareholder rule and ordered production of any documents containing that legal advice. The company appeals to the Privy Council. The Board unanimously advises His Majesty to allow the appeal. Lady Rose and I give the opinion of the Board, with which Lords Leggett, Lord Burrows and Lord Richards agree. Our reasons are, in summary, as follows. No one now doubts that the original supposed justification for the shareholder rule, namely that shareholders in effect paid for the legal advice out of their beneficially owned property, has been discredited for over a century. Since at least as long ago as the famous case of Salomon and Salomon in 1897, it has been generally understood that a company is both the legal and beneficial owner of its assets. More recently, the shareholder rule has been sought to be justified as an example of joint interest privilege, and that is how it was sought to be justified by the Chief Justice and by the Court of Appeal in the present case. Joint interest privilege has been applied so as to prevent those who obtain legal advice about a matter where their interests coincide later claiming privilege against each other when they fall out and become engaged in litigation. Examples include creditor and guarantor, insurer and reinsurer, insurer and insured, joint venturers, and trustees and their beneficiaries. In the Board's view, joint interest privilege cannot replace the now discredited proprietary basis for refusing to allow a company to claim legal advice privilege against its shareholders. In a large modern company, shareholders often have divided interests even between themselves, as illustrated by the support for and opposition to the amalgamation among Jardine Strategic shareholders, and by the sharp conflict of interest between the company and the opposing shareholders in fixing a fair price for the shares. And shareholders are only one, although a very important one, of the groups of stakeholders in the company, others including its creditors and its workforce. The directors have to take all these stakeholder groups' interests into account when deciding what is in the company's best interests, and frequently need to take confidential legal advice in doing so. The present appeal is the first occasion when the courts of Bermuda have had to decide whether the shareholder rule forms any part of Bermudian law. The supposed rule has suffered a checkered career in other common law jurisdictions, including Canada and Australia. It has come under recent criticism in England and was last year boldly rejected by the English High Court in Arbar Holdings SARL against Glencore plc, although that decision is subject to appeal. The Board's view is that the shareholder rule cannot be justified either on a proprietary or joint interest basis, and it amounts to an unwarranted impediment to companies obtaining confidential legal advice. It is, in short, like the emperor wearing no clothes, and ought to be declared to form no part of either Bermudian or English law. In 2016, in a case called Willers and Joyce, the UK Supreme Court decided that it was open to the Privy Council, in a case where the appeal concerned an issue of English common law shared by the jurisdiction from which the appeal came, to declare that its decision was to be treated by the English courts as representing also the law of England and Wales. Since the shareholder rule was the original creation of the English courts and has never been ruled upon by the House of Lords or the Supreme Court, the Board considers it appropriate to make such a declaration in the present case. That is why this judgment is being handed down orally, rather than just promulgated, as is the usual custom with judgments or opinions of the Board. There is being promulgated today a judgment of the same constituted Board in an appeal also arising from the Jardine litigation about the meaning and effect of the share value adjudication provisions of Bermudian legislation. That will be promulgated at the same time and in the same way, but does not need an oral hand down. The court is now adjourned.